Good afternoon, everyone, and thank you all for joining us for today's presentation for this criminal record expunction Listen and Learn. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. If you are unfamiliar with the format of this event, first we are going to watch an informational video on this area of the law. At the end of the video, we will have a question and answer session with one of our second chance attorneys. You can put your questions in the Q&A box on Zoom or in the comments section on Facebook at any time. We'll review all questions put in the chat boxes during the Q&A session. Please remember that this is a public forum and Legal Aid is not representing you. So please remember not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I will start the video. This presentation was created by Legal Aid of North Carolina. This presentation only provides legal information and not legal advice. The information presented is based on North Carolina law only.
What is an expunction? Expunction means to permanently remove an offense or a conviction from a criminal record. When an expunction is granted by the court, the public criminal record of the expunged offense or conviction is destroyed. Once somebody receives an expunction, they can truthfully deny that the expunged offense or conviction ever occurred. There are three primary types of expunction. There are the expunction of not guilty charges, the expunction of dismissed charges, as well as the expunction of convictions. We will review the three types of expunction. We'll start with the most common types of expunction, and then we'll get into the expunction of convictions. So the first type is the expunction of not guilty charges. Now these are all charges where someone was found not guilty of the offense that they were charged with. These types of charges are eligible to be expunged. Next is dismissed charges, and these are all charges that were dismissed. These are also eligible to be expunged. Now, most charges that are dismissed after December 1st, 2021 will be automatically expunged 6 months after they are dismissed. However, if somebody has dismissed charges prior to December 1st, 2021, they will need to file a petition to seek the expunction of those dismissed charges, and those types of dismissals will not be automatically expunged. All of that to say, if somebody has dismissed charges that were disposed of prior to December 1st, 2021, they are still eligible to be expunged. That person would just need to file the petition and file it with the court to seek that expunction, as opposed to most charges that are dismissed after that December 1st, 2021 date. Those will be automatically expunged from that person's record 6 months after the disposition. Now, let's talk about the expunction of convictions, and these are where somebody was found guilty or pled guilty to an offense that they were charged with. There are two categories of this type of expunction. There are what we call youthful convictions as well as adult convictions. Youthful convictions are also known as raise the age convictions. Now these are most misdemeanors and some Class HRI felony convictions that were committed before December 1st, 2019, when the person was 16 or 17 years old at the time of the offense. These types of convictions are eligible to be expunged. Adult convictions. These are some misdemeanors and few felony convictions when someone was 18 years old or older at the time of that offense may be eligible for expunction. Now, there are a number of what we call disqualifying convictions that could prevent somebody from expunging any of their adult convictions. Now, the law that speaks to the expunction of adult convictions includes a list of offenses that are not eligible for expunction, and the statute that speaks to that is listed on the screen. Now, if somebody has a conviction for any of these types of offenses, that person is not eligible to expunge any convictions that occurred when that person was 18 years old or older. However, that person may still be able to expunge any race to age or youthful convictions that they may have, and they are also still eligible to expunge any dismissed or not guilty charges that they may have. Some of the most common ineligible offenses include Class A through G felonies, such as common law robbery or the sale of drugs. We have Class A1 misdemeanors. The most common ones that we see are misdemeanor child abuse. Domestic violence protective order violations are also Class A1 misdemeanors. We have any convictions that require sex offender registration. We have assault offenses, so any offense where assault is an essential element of that offense. So, as on the screen, assault on a female, simple assault. If assault is in the name of the charge, it's likely going to be disqualifying. We have any offense that involves heroin or crystal meth. And then we also have possession with intent to sell or deliver cocaine, which we abbreviate to be PWISD cocaine. And this differs slightly from any felony offense involving heroin or crystal meth, because mere possession of those types of drugs is disqualifying, as opposed to cocaine, where felony possession of cocaine is not. There needs to be some further intent with cocaine in order for that to be disqualifying. And again, these are just the most common. There are a couple more on that list, but all of that to say, if somebody has a conviction for one of these types of offenses, what that means is that they are not eligible to expunge any adult conviction that they have on their record. Now, I'm going to walk through what the general expunction process looks like. This can vary in time, meaning it really depends on a multitude of factors how long this process can take. But generally, no matter what type of expunction someone is seeking, the process will look generally the same. And so the first step is obtaining an accurate and complete copy of the criminal record. In order to be able to move on to step 2, which is determining eligibility for expunction, somebody needs to make sure they are reviewing an accurate and complete copy of the criminal record that they are seeking to expunge. And so once somebody has that complete record, they can move on to step 2 and determine, based on what is on that record as it applies to the law, what may or may not be eligible for expunction. Now, step 3, if it is determined that someone does not have any offenses that are eligible for expunction, the process stops at this point. There are no further steps to be taken. However, if it is determined that somebody does have offenses that may be eligible for expunction, we continue on to the next step, which is to identify the correct petition form for that type of expunction. There are separate petition forms for each type of expunction, and these are standard forms from the Administrative Office of the courts. And so depending on the type of expunction relief somebody is seeking, there is a specific form that that individual would need to complete in order to get that process started. Now, once somebody has identified the correct petition form based on the relief they are seeking, they would want to complete it and any required documentation that may be needed depending on the type of relief they are seeking. That to say, when it comes to expunging convictions, there are supporting documents that are needed in order to support the expunction. And so that individual would need to not only complete the petition form, but also want to complete those documents and file those with the court at the same time. Once all of the petitions have been drafted and all of the supporting documents have been completed, the next step is to identify and follow any county-specific procedures for filing. And what that means is there are 100 different counties in North Carolina. And so there are 100 different ways that somebody could go about filing the petitions in the counties that they need to file in. And so depending on the counties that somebody is working in, they would want to reach out to that clerk's office to inquire about how best to get their paperwork filed as needed. Now, to this point, petitions for expunction need to be filed in the county and division where the expungible offense occurred. And what this means is, for example, if somebody has dismissed charges that are eligible in Wake County and Johnston County, that person would be completing at least 2 different petition forms, one for the dismissals in Wake County and one for the dismissals in Johnston County. Now let's say in Johnston County that person had dismissals in Superior Court as well as District Court. That person would be filling out 2 different dismissal petitions, one for Johnston County District Court and one for Johnston County Superior Court. And so when we say they need to be filed in the county and division where they occurred, that is an example of what that may look like. And so if somebody has a record that spans different counties and different court divisions, depending on the relief they are seeking, there could be a number of different petitions that need to be filed. Now, once somebody has filed all of the expunction petitions that they have worked on and are waiting to hear back from the court, again, how long that takes can vary county to county. But ultimately, by the end, that individual should receive the expunction petition that they filed, either denied by the court or hopefully granted by the court. And if the petition is granted, that means the expunction was granted by the judge. And so if somebody receives a granted order from the court, what they would want to do at that point is to verify that that expunction was certified. And what does that mean? There are public terminals in each courthouse where somebody can input their information to confirm that the expunged offenses no longer show up in that database. And that is the ultimate goal, because if somebody were to type in the file number of the expunged offense, it should no longer show, meaning that the clerk, upon the granting of that expunction from the judge, has gone into their system and deleted reference of that expunged offense from the public database. Now, to that point, again, to reference back to the beginning of this presentation, expunction means to remove the public criminal record of an offense or conviction. And so to that end, there are still certain agencies that are still able to access expunged records. However, as I will get into in the next slide, they can only access them for very specific purposes. So access to expunged records. These expunged records can still be accessed by prosecutors. So these are district attorneys. They can still see and use expunged records for sentence calculations. So meaning if somebody were to be charged with another offense and they are subsequently found guilty or plead guilty to that offense, district attorneys can look at expunged records that that person may have had in the past and can use those when it comes to determining the person's sentence for that new offense that they were found guilty of or pled guilty to. Additionally, they can also use it for what we call habitual offender status. So again, it's kind of the same concept. If somebody is charged with another offense, plead guilty, found guilty, district attorneys can use the expunged offense to determine if somebody should be classified as a habitual offender. The next entity that can see them are arresting agencies, and that is because they keep what are known as investigative records, and the database that they use is not available to the public. And so if somebody doesn't work in an arresting agency, they're not able to see or access those records. And so they are not required by law to delete expunged offenses from their investigative records. And one of the main reasons is because it's not publicly available. And last, we have law enforcement agencies, and they can see expunged offenses and records for employment purposes. So if somebody is seeking to become employed at a law enforcement agency, that agency can see expunged records if that is the case, if that person has any of those. And then additionally, for certification purposes. And so if somebody is looking to obtain some kind of certification within the law enforcement agency, they can also see expunged records for those purposes as well, in determining whether, somebody should be hired or if somebody should receive that type of certification.
This presentation was brought to you by Legal Aid of North Carolina. Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services in civil matters to low income people in order to ensure equal access to justice and remove legal barriers to economic opportunity. Legal Aid of North Carolina offers listen and learns on several topics, including criminal record expungement, child custody, Medicaid rights and eligibility, simple divorce, Social Security disability, SNAP benefits, tenant rights, and wills and powers of attorneys. Now that the video has ended, we will begin the Q&A session. Remember, if you have a question, you either need to type it in the Q&A box on Zoom or put it in the comments section on Facebook. You cannot unmute in this forum, so if you have a question, you either need to put it in one of those boxes. Today, we have our star of our video here, Lorena Evans, to answer those questions for you. Please remember that while Lorena is an attorney, she is not your attorney. She cannot respond to specific legal questions. And I will get into our first question.
Thanks, Marissa.
Clarifying question. Someone's asking if one of their convictions is for assault, does that mean none of their convictions can be expunged?
Generally, yes. And so when you're looking to see if convictions are eligible to be expunged, we're going to look back to that statute 145.5, which is just the number of the statute. And offenses where assault is an essential element of the offense are one of those disqualifying offenses. And so if somebody has a conviction for an assault where assault is in the name of that offense, it is likely that not only is that conviction not eligible, but all of your other adult convictions are also not eligible. I say adult convictions because, like I mentioned in the video, if somebody has eligible youthful or raise the age convictions, those can still be expunged. What would ultimately be left would just be the adult convictions because of that disqualifying assault.
Perfect. And I think this next question is asking, I think it's asking if for something that's been expunged, something like a law school or a law firm for employment, would that be do they use public records or would they be able to see expunged offenses? I think that's what this question is asking.
Okay, that I mean, I wouldn't know because I don't work for the law school, the law firm. And so I don't know the ins and outs of what types of background checks that they use, but essentially if they use a third-party background check company, they shouldn't be able to see those expunged offenses or convictions. I say should because a lot of those third-party companies don't update the data that they use as often as one would like. And so sometimes there are situations in which expunged offenses can still show up on those. But if that happens to somebody, there are remedies that that person can take to request that they remove that expunged offense. And so really it's a depend answer. You do have the right to request the background check that an employer, potential employer does to be able to review. And so that could be an option for somebody who is applying for a job or any kind of application where they do run a background check.
Perfect. And clarifying question. If the assault charge was dismissed, is it still an ineligible offense? Or I think you
The
don't understand.
Yep, thank you. Yeah, so the determining factor is whether that person was convicted of that type of offense. And so if somebody was charged with a Class G felony or somebody was charged with an assault and it was ultimately dismissed, that is not disqualifying because the disposition was a dismissal. That person wasn't found guilty, didn't plead guilty. So really what you're looking at is whether somebody was convicted of one of those types of offenses. So if somebody was charged with an assault, it was dismissed, that wouldn't be disqualifying because that person ended up getting the charge dismissed. And dismissals are eligible to be expunged. So that person could then seek the expunction of that dismissed assault.
Perfect. Can you speak to traffic infractions at all? Someone's asking, is DWI something that impacts expunction?
So DWIs actually used to be one of those types of disqualifying convictions. Legislature realized that that disqualified a very large amount of people, and so it is no longer a type of disqualifying conviction, but it is in and of itself disqualified from being expunged. So what that means is if somebody has a DWI conviction, that alone doesn't disqualify them from expunging convictions if they don't have any other types of disqualifying convictions. But the DWI itself is not eligible to be expunged, and that will remain on the record. And so if somebody has a DWI conviction, it's not eligible to be expunged. It will remain on the record. And so hopefully that answers the question.
I believe so. Do you know the exact form that someone would use to petition for an expunction?
The form numbers are different depending on the type of expunction. And so usually when looking, I tend to search by the statute number on the NC Court's website as opposed to the form number, because that's just easier to remember. And so 146 would be the dismissals or the not guilties, as mentioned in the PowerPoint. The adult convictions would be 145.5, and then the raise the age youthful convictions are 145.8A. But I honestly don't remember the statute numbers the form numbers off the top of my head because I just searched by the statute. But I think dismissals might be 287, and then I think it goes like 288 and 285, I think. But they're all on the NC Court's website, essentially.
Is the court able to? Okay, hold on. Will the court be able to open documents on you after? Can a court tell you which of those documents, which forms you would need? Like if you were to go to a clerk and explain your situation, would they be able to tell you that information?
The clerk is likely not going to tell you which form you'd need because they're likely wary of leaning into giving legal advice when they're not attorneys. And so the easiest way to find would be probably searching, like you can go on the NC Court's website, if you have a desktop or if you have a phone that has that ability, and search on your own device. And by searching the statute numbers on the forms themselves, it says in the top right corner what type of charges or convictions go on that form. And that's likely going to be the easiest way to tell you what form you would need for the type of expunction. So for dismissals, it says dismiss charges in the top. For not guilty, it says not guilty. And for the adult convictions, they're separate from misdemeanors and felonies, but at the top of those, it says misdemeanor convictions or felony convictions. And the same goes for those under 18 youthful convictions. And so really just the easiest way to tell would be look at the top right corner of the form, and that's should hopefully indicate to you which one you would need depending on the type of relief that the person is seeking.
And I just put a link to that NC Court's website that Lorena mentioned
Awesome.
that you can look at to try to look up some forms if someone needs that information.
Thank you. And there is
Um,
like a drop down right in the corner that says forms. If you just click right there, that should get you to where you need to be.
how does someone find their criminal record?
That is a great question. It's not in North Carolina, there are multitude of places that one person can use to find their criminal record. I will say for us here at Legal Aid, we search two different databases. It used to be three, but with the new eCourts e-filing system, now it's only two. And so what we look at is the North Carolina Department of Adult Corrections offender search. And that is usually going to show if somebody was convicted of an offense where they served either supervised probation or an active sentence. And so not everybody who has a type of criminal record will have a North Carolina Department of Adult Corrections record because it only shows those types of convictions where somebody served supervised probation or some kind of active sentence. So in addition to that, we searched the eCourts portal system, which is the new North Carolina system to search records, not just criminal records, but just general court records as well. And so, as I mentioned in the video, there are public terminals at the courthouses, but now you can actually go online to the NC Court's website, like I just mentioned, with the forms and search the portal system at home, and you don't need to go to the courthouse to do that. And so those are the two places that we search, and we cross-reference those, and then obviously reach out to our clients to make sure we have everything that we need. But you could also go to the clerk's office in the county where you have records, and you can request a certified record from that county, but they're only going to provide you records from their county. And so if you have charges in multiple counties, if you were going to do that, you would have to go to each county where you have records to request them. You could also request an SBI record, the State Bureau of Investigation record. That may have some offenses that are on a criminal record, but that's not comprehensive, usually only shows records where someone was fingerprinted. And so the struggle with a lot of these places to find records is not one of them is completely comprehensive. And so a lot of times, like we do here, we will search a couple, cross-reference them, and then of course, as the individual who's pulling their own record, you would know, if that is an entire record for yourself. And then us as advocates, we always just confirm with who we're working with to make sure that we have everything. So not an easy answer. There are many places to get a criminal record, and you're likely going to have to seek out more than one if you have a lengthy record.
Is there a statute of limitations for an expunction? Like if you wait too long after conviction, does that prevent you from being able, if it was an expungable offense?
There is not a statute of limitations per se, but that in the reverse, there is a waiting period for expunging eligible adult convictions. And so really you have to wait a certain amount of time before you can expunge convictions, depending on the type and how many that you have. And the wait periods range from 3 years for one single eligible misdemeanor up to 20 years for up to 3 eligible felonies. And so there's not a statute of limitations, but there is a statutory wait period for each type of expunction relief when it comes to adult convictions that person would have to wait before they proceeded with an expunction. For dismissals and not guilties, you can file those as many times as you need as soon as the case is disposed. So if you went to court tomorrow, got the charge dismissed, you could come back on Thursday with the petition ready to file and start that process. For raise the age, youthful convictions, it's only, there's no waiting period beyond just completing the sentence that that person was ordered to complete if they were for that offense. And so there's not a statute of limitations. There's really actually a waiting period that has to be met for expunging adult convictions.
Um, for a conviction in a different state, can a North Carolina lawyer assist with that? Or is the process the same in every state?
The process is not the same in every state because expunction law is state specific. So I'm an attorney licensed in North Carolina. I can only advise and assist with North Carolina criminal records. And so for individuals, for example, who reach out to legal aid and they have criminal records in Florida or Georgia, the most that we could do would be to try to find a similar organization in that state and try to refer that person to that organization who may then be able to help them. And so there's nothing that a North Carolina lawyer could do or that the North Carolina court system could do regarding those out of state charges. That person would need to seek counsel from that state to see what the possibilities might be for that record.
And then just to clarify again, regardless of how old the assault charge was, an assault conviction is disqualifying. Correct?
Yes, yes. The law, when it comes to disqualifying convictions, the law does not take into account how long ago that offense or that conviction occurred. So, yes, doesn't matter if it was a year ago, 20 years ago, 10 years ago. If somebody has a conviction for an assault offense, that is disqualifying. There's no like, if I wait 30 years, then it becomes no longer disqualifying. Like, that's not a thing. It's just purely if you have a conviction for that type of offense, you are disqualified. It doesn't matter when that conviction happened.
Um, what's the price for filing for an expunction? What's that look like, the fees?
Yep, great question. So there are filing fees for certain types of expunction petitions. So generally, for not guilty petitions and most dismissal petitions, there's not a filing fee. So all the person would need to do is complete the form and take it to the clerk's office in that county. If somebody is expunging dismissed charges that came about through a deferred prosecution agreement or some kind of conditional discharge, which generally looks like you were charged with an offense, the district attorney's office offers that you complete this anger management or this drug treatment, or you go on probation for 12 months. And upon the successful completion of that agreement, they will dismiss the charge. So they defer the prosecution to give that person time to complete whatever they require of them, and then they dismiss it. Those dismissals are still eligible to be expunged. There is just a $175 filing fee. For youthful convictions, the filing fee is $52.50. And then for any expunction petition, when it comes to expunging adult convictions, that filing fee is also $175. Now, there is a way that you may be able to get that fee waived, and you may file a petition to proceed as indigent along with those petitions. And so essentially that is just saying that you would like to file this expunction petition, and the court should consider you as indigent, so they should waive the filing fee so that you don't have to pay. And so if somebody is a client of ours at Legal Aid, we can file that indigency petition on their behalf because they're represented by a legal services organization like Legal Aid, and that often gets the fee waived. If somebody isn't, if they are a recipient of SNAP or food stamps or SSI, there is a box on the form that person can also check that can allow the court to waive that fee. Now, that person may have to come prepared with the paperwork that shows that they are a recipient of that kind of government assistance, but they may be able to get the fee waived that way. Otherwise, if not, then you would have to pay that filing fee when you go take the petition to the clerk's office.
Perfect. Hold on. And then, don't know what that means. Okay, I think last question here before we get into reaching out to the Glade. Someone just clarifying about DUIs. Those aren't eligible for expunction.
DWIs, which is interchangeable with DUIs, but it's under the law, it's a DWI, are not eligible to be expunged if it's a conviction. Now, if somebody was charged with a DWI and they were found not guilty, or it was dismissed because it was dismissed, or they were found not guilty, it would be eligible then. But if somebody has a conviction for a DWI, that is not eligible to be expunged, and it will stay on the record.
And then got a couple people asking about potentially getting assistance from legal aid. Can you explain maybe getting some expunction help from legal aid in that process at this time?
Yes, we are still, as a team, the Second Chance Project, are still working out what our intake schedule is going to look like in the upcoming year. And so I don't unfortunately have an answer for you all today, but I would just refer you all to check back on our website. Our project has a page on the Legal Aid North Carolina website. That is where we put the most up-to-date information about our intake schedule. Generally, we are a statewide project, and so any information that we have about our intake schedule will be on that page. And so I would just encourage you to keep checking back as soon as we have that information kind of finalized. We will update the website to illustrate that.
Awesome. And as I am seeing no more questions that we can answer, I'm going to go ahead and say thank you to all of you for joining us, with a very, very special to Lorena for presenting and for presenting and answering all those questions. If you would like to review anything that was discussed in the video or any of Lorena's responses, you can watch this recording on our Facebook page. It will be immediately available on Legal Aid of North Carolina's Facebook page following this presentation. For about 30 days. In about a week, it will be available on Legal Aid's YouTube page to be viewed at any time. If you'd like to register for one of our other listen and learn programs, such as mentioned in the video, child custody, simple divorce, tenant rights, right now our schedule is only through the end of 2025, but we are about to start adding our dates for 2026. So please be watching Legal Aid's Eventbrite and Facebook page for information on further presentations. I'm going to say thank you all to join us, and I hope everyone has a great rest of their afternoon.
Thank you.